So welcome back everyone. So we will be continuing our subject, that is BSA. So really sorry for the inconvenience. So we were not able to take up the lectures for I guess more than 1 month. So I was quite busy with my personal work. So from now onwards we will be completing our subject on the daily basis. So in the previous sessions we have completed up to primary and along with the secondary evidence in relation to a particular document. So I think we have completed till section 73, how attestation is done for the document which is required by law to be attested. So we have discussed the procedure regarding that. We have taken complete one session for that, how a document which is required by law to be attested, how it is need to be proved before a court. So as of now, we will be starting with the fresh topic, that is the types of documents. So basically, first we have covered the different category that was in relation to the evidentiary value of a particular document, that is whether it is a primary document, which means pratham sakshya, or it is secondary document, which means gatham sakshya. So that helps in the giving the more credibility to a particular document. So if the document is primary nature, then it will gather more credibility, and along with that it will be of higher footing in relation to the evidentiary value. So as of now, we are coming to the second category, that is in relation to the accessibility of a document. So what types of documents we can have access? So there are two types of documents. One is the public document and another one is the private document. As the name suggests, so public document will be accessible to the whole public, but in relation to private document, it will only be accessible to the parties who are party to a particular document. So on the basis of the accessibility, so documents are divided into two parts under section 74. That is a public document and another one is the private document. So section 74 has provided the exhaustive list. So section 74 provides the exhaustive list which covers the head of public document. So all the documents which are included in that particular list, which is exhaustive in nature, so those documents will be public documents, and all the documents which are excluded, so all those documents will be considered as private document. So as of now, we will analyze the statutory provision, that is the section 74. So let's begin. So first document that it is talking about, document forming the acts or records of the acts. So documents which relates to the any functioning of a sovereign authority. Sovereign authority means which is not under influence of any other person or any other institution, which means the authority which is running the government. So any record or any act which is formulating a document of sovereign authority, which means the government, any government authority, which can be state government or it can be central government. So any document which is in relation to the act or record of that particular sovereign authority will be a public document. So any document which is in custody of government relating to the act or record of that authority, which it will be a public document. So every person will have a right to access of that particular document. ठीक है जी. So after that, any document of official bodies and tribunals. Official bodies means अधिकृत समुदाय और न्यायाधिकरण जो ट्रिब्यूनल्स होते हैं. Tribunals means, so these are the quasi judicial bodies. These are not particularly judicial bodies. Tribunals means the quasi judicial bodies which are established under article 323A of the Indian Constitution, that is in relation to Central Administrative Tribunal, which deals with the disputes of the public servants, and along with that Article 323B of the Indian Constitution, any tribunal established under that article and the document which is forming the act or record of that particular tribunal or any official body will be a public document. So any person can have access to that particular document. So after that, the document by any public officer or legislative, judicial or executive of India or of foreign country. So any document which forms the record or act of any public officer means any gazetted officer who is functioning for the public, or any legislative body includes state legislature assemblies and state legislature councils, and along with that Lok Sabha, that is in relation to central government, and Rajya Sabha. And judicial bodies means all the courts that are instituted in our country, and along with that all the executive bodies of India. Executive bodies include the ministers, council of ministers, and in relation to a state, chief ministers, and in relation to central government, the prime minister and the president, and at state level the governors. So any document which forms the record or act of any public officer or any three pillars of the government, that will be a public document. So it is bit obvious. So any document which is prepared by the government authority, that will fall under the category of public document. ठीक है. और इसका एक समुदाय हमने पढ़ लिया है, और दूसरा समुदाय अगर चाहे वो फॉरेन कंट्री भी हो, फॉरेन कंट्री मीन्स विदेशी राज्य, अगर वह दस्तावेज विदेशी देश का है और किसी सार्वजनिक अधिकारी या विधायी या न्यायिक या कार्यपालिनी ने के द्वारा बनाया गया है, चाहे वो विदेशी देश है, वह दस्तावेज भी अपना सार्वजनिक दस्तावेज कहलाएगा. और इसका एक हमने पढ़ लिया, और दूसरा पार्ट दैट इज इन रिलेशन टू सेक्शन 74 सबसेक्शन 1 क्लॉज बी. सो पब्लिक रिकॉर्ड्स kept in any state or any union territory of private documents. So कोई भी प्राइवेट मीन्स व्यक्तिगत दस्तावेज का रिकॉर्ड अगर स्टेट या यूनियन टेरिटरी ने अपना पब्लिक रिकॉर्ड मीन्स सार्वजनिक रिकॉर्ड्स में अगर दर्ज किया है, तो वह व्यक्तिगत दस्तावेज भी एक अपना सार्वजनिक दस्तावेज कहलाएगा. So for example, when we do registration of immovable property, when any immovable property of value of more than 100 rupees or 100 rupees is registered, so registration is done in the office of revenue officer, that is the registrar office. So when it is being registered, so that is the document between two parties, one is the seller and other one is the buyer. So it is the agreement between two persons, that is in relation to sale and purchase of a immovable property of value more than 100 rupees. So it is being recorded at the registrar's office, and that document can have access to any person. Any person can pay the prescribed fees and can call for the certified copy of that particular agreement, that is in relation to sale and purchase of personal persons, even though चाहे वो किसी दो निजी व्यक्तियों के बीच का अनुसंधान है, लेकिन उसका कॉपी कोई भी ले सकता है, या उसका प्रोसेस फॉलो करके सर्टिफाइड फीस जमा करा के अपनी सर्टिफाइड कॉपी ले सकता है. So that is in relation to public records kept in state or union territory of private documents. So we have completed the definition of public documents. So all those documents which come under this definition will be public documents, but all those documents which are excluded or does not come under this head will be private documents. So keep one thing in your mind, you have to just apply the statutory provisions, whether the document falls under any of that head. If it falls, it is a public document. If it does not fall, then it is a private document. So section 75, it deals with the certified copies of the public document. As we have already studied, certified copy is the secondary evidence of a particular document. So any public document, we can have access of certified copy. Certified copy means it is the copy provided by the public officer by affixing his seal and writing date on it and signing below the head of the document, and official title is written, and along with that subscribed by that officer and seal, and that certified copy is given to a person who has applied for that particular copy. So section 75 provides for the certified copies of a public document. So, and section 76, it provides that those certified copies can be given in evidence. So evidentiary value of that particular certified copy will be of secondary nature. As we have already studied under section 58 of the Bharatiya Sakshya Adhiniyam, that is in relation to secondary evidences. So any certified copy of a public document will be a secondary nature. So we have completed the demarcation between the public and private document. So as of tomorrow, we will be starting with the new topic, that is in relation to presumptions. So there are two types of presumptions. One is the shall presumption, where the court is duty bound to presume the genuineness of particular fact or particular document. And another one is the may presume, where the court has discretion to apply judicial mind whether to take the presumption or not. And that we will be studying tomorrow. So first we will understand the particular meaning of shall presume and may presume, and after that we will cover all the presumptions that court is supposed to take regarding the documents. So from section 78 till 93, so these are the presumptions in favor of particular documents, and there are two types of presumptions. One is the shall presume and another one is the may presume. So thanks for today. We will be completing our session. So tomorrow we will be starting the presumptions